Folks, we have Jessica on the phone tonight, and this was basically for her, and if folks want to type in something or call in, that's fine. There's only 3 people that show up, that's fine too. We won't do this too long. Because, when is your hearing, Trump?
The hearing is Wednesday.
It's Wednesday, see, and they're calling it a hearing, see, so, we'll work on that a little bit too, and like I said, a lot of folks that, you folks listen to on the internet, like, you know the names. I'm not going to whip out these people's names. But these people, when I start to speak with them, I say to them, the words are imperative what you use. And they try to say, well, hearing and trial is the same thing. It's not even close. Yeah. So when they say it's a hearing, you want a trial. And but they're saying this is a hearing. So whose hearing is this? Because like in common law, it's a trial. And for a hearing, would be set up because this is like a preliminary hearing. That's okay. You could have preliminary hearings in common law. Right. Say, look, you can hash this stuff out before the trial. But you're saying you want the return of your property. It's like, I don't want a hearing over this. I want a trial over this. I want it and I want it now. I don't need a hearing. I know what I want. I want 1, 2, 3, 4 of those things returned back to me. That's what I want. I don't have to have no hearing over this. I'm telling you, it was the President of the United States property, and he had 1, 2, or 3, 4 sitting someplace. They'd have a trial, they'd have it now. They ain't going to have no hearings. He's going to run through that court like lightning. So that's the same what you're trying to do. So this hearing stuff is kind of cute, or maybe sounds less. There's a trial, but if you want a trial. So the whole trick is when they define it as a hearing, they're setting up the rules. So when they set up the rules, then who makes the rule, also makes the decision on how it is, like a referee. Right. It's like, I wrote the rules. Don't tell me what just happened here. Don't just tell me who complied with the rules or who didn't comply with the rules. I made the rules. We're operating under these rules, and I'm the man in a black robe, and I've been studying these rules for 50 years. Believe me, nobody can interpret these rules like I can. Like, you just learned these rules 2 weeks ago, and you just, got a YouTube video, so, don't tell me what the rules are.
Yeah.
So that's exactly the attitude the person in the black robe is going to have towards you. Like, believe me, I'm a master, so you're not. Sit back and let me do my job, okay?
Yeah.
Just fixing the transmissions on basis. So you have any clue what this is, lady? No. Then just sit back and let me do what I got to do. Now, if you trust the man in the black robe, that's lovely. But to me, it's like, I'm not putting my faith and trust in somebody I don't know. My mama taught me, well, strangers a danger. I don't trust him. I don't believe he's here for my best interest. I believe that he has an ulterior motive and he has an agenda and he's here for a reason. Or he might be the sweetest man in the world and might feel bad for failing. You know what? Either way, I still like to flip a coin and he hopes that he moves in my direction today. I'm going to order him. If the other people sitting on the other side from me do not have a proper claim before this court for that property, I want it returned now. The only thing I need you, man in a black robe, is to record what happened between me and a person sitting next to me on the opposite side. Did they or did they not have a proper claim before this court? Yes or no? So if they do have a proper claim, you say, fine, Mr. Man or Mrs. in a black robe, set us for a date for a trial tomorrow, and we're good to go. So to me, if you want to say that, that's fine. You're moving your claim before the guy in a black robe or a clerk court. That's what you're basically doing. Or a magistrate. A magistrate is supposed to be the one who helps set the table. Like I said, if you go back in some guys are funny, and they take apart the word magistrate, say magi, black robe, evil, devil, all kinds of nonsense. I just go back and make it simple. Well, magistrate just meant the person who the king would say, we need more water here, we need more wine, bring me out some more silverware, bring some salt. He would help the court arrange the menu to hold court. That's what a magistrate did. He was a flunky boy. He ran around and made sure everything was being done. So that's all you basically want. You just want some boy to run around to make sure that he helps you get your job done. So that's all you're trying to do. You're the king, you're the queen. You're trying to say, hey, I need you to move around these tables, move these chairs, do this, do this, do this. I need you to perform a service for me. That's a magistrate. You don't need him to be the king of the court. You're the king of the court. You're the queen of the court. I don't need to in this court. I'm doing just fine. The magistrate could suggest to you that's exactly what a magistrate is. He's a referral or a referral, somebody who refers and gives you suggestions on where we should go next and how we should hold court. That's fine. Because sometimes in history, a king or queen was 5, 6, 7, 8, 9, 10 years old. And you needed somebody to, sit in and explain to the king what he should do next. Now, raise your left hand, lower your right hand. You needed that, at the time when the king or the queen, is basically incompetent. But you're trying to say you're competent and you're going to move, beyond this court into that venue. So what I would do, if I was you, I would write a little notice that the honest court will be holding a return of property hearing on Wednesday. They say you folks may refer to that as a habeas corpus procedure. And you could, like I said, you could attach it like what Canadian habeas corpus basically operates by certain rules, but that doesn't mean you're going to operate by those rules, but, similar to a Canadian rules of habeas corpus, whatever you guys have up there, whatever, 601, whatever. I saw it on some, it used like 24B or something like that, multiple jurisdictions, different venues, or whatever it was, that's fine. But I would just make a notice to the court, you're telling, this is hard to people in court. You got A court, B court, court. It's the honest court moving into court. Like you're trying to, it's like a husband and wife. Well, before you guys get married, you're courting the woman. So you're courting them. You're trying to make them see it your way. So it's like a courtship. So what you're doing is you're trying to present them with a gift. You're making a presentation of your claim.
Right.
So if a guy's got $1 million claim for a gold mine, he presents that to a woman, says, "Will you marry me?" She says, "No, not until I know that you got some money to support me." He said, "Well, look, I got a claim for a gold mine." "Well, hell, let's get this marriage thing going."
Right.
Then you move on from there. But like I said, so what are you doing? You're basically trying to court that tribunal there. So all you're doing right now, though, if this is a hearing, which is fine, it's fine. You say, look, our next court is going to be holding a hearing on Wednesday at what time? Like 9, 10, 11?
9 o'clock.
There you go, 9 o'clock. And you say, at this building, at this courtroom, blah, blah, blah. Say, you just lay out the rules. Say, at this time of this hearing is going to be all offers or counter offers, all claims to property 1, 2, 3, and 4 are to be tended to court at this time because you're the court. Or you could say, oh, that's what this makes them really upset. You say, to be tended to said SAID, said court. So that's where you don't have to keep saying on S court. You say said court. Say all offers for any interest or claim in property 1, 2, 3, 4 is to be tended and delivered upon, said court. On that date, we will accept claims from 9 a.m. till 10 a.m. Say when all claims have been properly delivered, we will set a trial date a week from today, and we'll have the trial by jury, in which the claims will be presented to the jury. The final determination of all claims. Say if no claims come forward by 10 o'clock a.m., the magistrate will record through the clerk's office that no claim has came before court and that the property is to be returned to the honest court at 10:01 a.m. And then once that's it, make it something just that simple. Thank God I don't have to see. That's why I say that God I don't have to repeat this a million times if 100 people this. So now you understand why. It took me 10 minutes to tell you what to do, and it's only going to take 3 or 4 sentences to do it. But now you understand. I said just wait a couple hours and let me get a little thing going, and from now on, people who see it says court decorum. What does call mean, court decorum? Well, you don't know what decorum means. Well, that's fine. Just listen to Karl's thing, and you'll figure it out.
That's right.
So then the only other thing that you could do is you give a notice. You make a separate notice now. Now you make a separate notice, court decorum. Notice of court decorum. Say, I am the prosecutor of this matter. The honest court will be prosecuting their claim in this venue at 9 a.m. The honest will take the left desk. Any claimants, any counterclaimants, or any other future claimants, or any claimants to be, will sit at the right desk, at the right-hand desk. Like I said, I basically said that prosecutor and defendant. Anybody who also wants to make a claim. I'm forward. But see, this is what you're trying to do. You're trying to say, make a notice, because what they're going to try to do is they're going to try to say, well, you're the defendant, you sit at the left table. He's the prosecutor, he's the state, he always sits at the right. Oh, they get really upset when I take over their table. They said, no, I'm prosecuting this claim. And they go, no, the state always sits over there. Well, you know what? At this point, I'm prosecuting this claim. They're like, whoa. I said, look, you know what? I'll cross your phone. I'll sit over on that left table. I'll sit on the floor. You know what? I don't care where I sit. But I'm telling you right now, as long as all parties know here, in this venue at this time, it is the Lentz court, and I am moving this claim. I don't care if I sit on the ceiling.
That's right.
You guys got 1 hour to get all the claims before me, presented to me, and it's done. So have at it. So like I said, if the judge tries to see, when a judge is trying to do a hearing, if he's trying to say, well, if he's going to ask questions, you have to try to say to him, sir, what are you doing? Like, I object. What? Are you making a claim for my child? No. Then why is not the people to my right not addressing me? Why are they not telling me that they have a claim for my kid? Are they thinking you're judging this matter? You know, like, well, this is a habeas corpus hearing. They'll say, this is the hearing for the return of my property. And the judge will say, well, I thought we already discussed this. This is habeas corpus. And say, well, honestly, sir, what rules are we working under? And he'll say, well, you know, if you don't know what the rules of habeas corpus is, I advise you to get an attorney to appear here and advise you. That's what he's going to do to you.
Right.
So even though he might have been nice and sweet as pie before this hearing, once he gets before it, he's going to turn into a tiger.
Yeah.
So like I'm trying to tell you folks, you have to get the rules of the court. The honest court is making more claims. You know, this is not a habeas corpus hearing. This is not operating under Rule 24A of the Canadian Code, whatever. This is a return of property hearing. Today we accept all claims to the property or vested interest in the property. Any interest in the property or any claims to the property, let it be brought forth now for hold the peace. It's the kind of right, something nice and sweet like that. And this is not operating under any Canadian Act. Like, I don't know what the Canadian Act of habeas corpus is. I mean, I've never studied it. I'm sure you have by now. So what do you think it is? You have any idea?
It's under the Judicature Act.
There you go. So, yeah, tell us what it is. So if other Canadians listen one day, they could look it up.
We just know that the habeas corpus was repealed last year in Canada, and they replaced it under the Judicature Act. So we're actually going to be making a precedent by using this this particular junction. But they basically follow in New Brunswick, Canada, Rule 69.1 or something of the judicature or the court rules. So.
Okay. So you said it's called Judica. How do you spell that?
J-U. You're going to have to write it down first. Judica. Judicature Act.
Alrighty. That's good, because I was having a hard time understanding the last 4 letters. I couldn't understand. It's G-U-R-E. I couldn't understand what you're saying. So you kind of losing me as well. So if you were losing me, I know other folks will probably say, what did she say? And make it repeat it again. So like I said, it's pretty simple what's going on. And the whole thing is you have to give the court notice of the rules in which you're moving under. So if I was you folks, I would figure out some sort of thing tonight, go down tomorrow and hand it to the court clerk, give her 2 copies. She'll get one to the judge or whoever's going to be sitting there in the black robe that day. And to the other side. That way everybody knows the rules that they're going to be walking into when they come tomorrow. They know, like, just because you're sitting on the state side doesn't mean you're the prosecutor. This doesn't mean that I'm defending anything. Doesn't mean I'm not guilty of nothing. You see what I'm saying? But they're going to try to put you in the defendant box.
Right.
When they see you take over the prosecutor box, they'd be a little upset, wouldn't they?
Right. And we've already established when we've gone in there that we were going in as the prosecutors of this case.
Right.
It's all in the paperwork as well.
So what's funny is you could actually do that in open court. Say, would you folks have a problem switching tables? Because honestly, we're the ones prosecuting this claim.
Right.
You could be a little like that, but don't be snobby. Just say, you know, I want you to get this established, you know, but like, put it in a note that this is how it's going down. No matter if I'm sitting on a ceiling tile, it doesn't matter. I'm still the prosecutor.
Right.
If you want to disrespect me, that's fine. You know, but let the fact be known that I am the prosecutor of this claim. And no matter where I'm sitting, don't think for 1 second that I the rules and the procedure in which this court is moving. That's the whole thing.
And
So,
essentially we want to say as little as possible when we're in the courtroom as well, just let our claim speak for itself.
your claim speaks for itself, your order speaks for itself, and your notices speak for themselves. So you're given a notice, so if somebody says something, he was like, didn't you get the notice we gave to court yesterday? Gave to your court lady yesterday? Like, yeah, didn't you get a copy of the notice yet? What are you folks doing? It's like, well, no, they're presenting their claim to me, and I'm going to determine their claim. It's like, no, they make their statements and claims to me. Do they have it in writing? What are they going to present to me? And when you see the state side show up, you say, whatever his name is, do you know what the prosecutor's name? Oh, well, what do they call them up there? What do they call
Crown counsel, they call them for the other side.
Right. So, what is his name? Is it like Bob or
Yeah,
Judy?
his name's David.
Good. You refer to him as David.
Yeah.
That way you say, David, do you have a claim that you'd like to present the honest court today? And it's like, well, I'm not even talking to you. I'm talking to this guy up here. Oh, he's going to do it. And that's lovely. Because that's showing that he has no claim to present to your court. So as long as you put a common law, it's supposed to be offers going back and forth between you and him. This is like, say, like a preliminary hearing before trial.
Right.
So it's like, oh, look, it's prima facie evidence that you have no claim to present to the honest court today. Is that true? Well, I don't. Well, there you go. Then you say the magistrate, you say to them and say, well, we'll give them another 55 minutes for anybody else to appear and make their claim for property 1, 2, 3, and 4. You people like to refer to them as children. That's your beliefs. That's fine. But that's not their beliefs. They maintain a position. See, when you ever act in the two-dimensional world, you maintain a position. When you're a man, you have a belief.
Right.
If you want to trick, what do you say the counsel's name was? Bob? David.
Yeah.
Do you want to trick David? You say it's after you believe. Ho, ho, ho. That keeps me from the law. If you say, do you maintain that position, David? Well, then you're saying, well, you recognize the attorney for the state, or whatever you folks call him up there. What's he represent?
He represents the Crown, so he's the Crown Counsel.
But I'm saying, what is the agency you folks are dealing with?
Oh, the Social Service, Minister of Social Development.
There you go. Wow, what a goofy name.
Yeah.
Okay. What Minister of what?
Social Development.
Okay, like Mazd. Okay, I'm trying to remember how to remember like Mazd. Okay, Minister of Social Development. Oh, wow. Okay, but anyway, you see what I'm saying? You're trying to say, is Mazd, is Social Services going to make an appearance today and make their claim? It's like, well, no, I'm going to make their claim. It's like, okay, well then, you're going to make the claim, and then they're going to appear at trial. So I can cross-examine them. You're not going to be like, well, there's going to be nobody to cross-examine. Well, then, are you trying to just, commit marriage here? Or are you just trying to interfere with justice? The process of justice here? Are you making a false claim? Then he's going to be like, because if nobody's going to be able to come forth and testify and hold down the information that what they say is true, how do you propose, or what would be the purpose of having a trial in a week from now? What would be the reason? Will your client appear or won't the client appear? See, and that's the whole thing with common law. They have to appear to make their claim. Like I said to you the other day, I said, can you imagine if somebody just dropped a couple of babies, 4 babies off of my front door? I said, what's that? Oh, your attorney for you? Yeah, I remember I had an attorney a couple of years back. Well, he made a claim on your behalf, and he said you wanted kids because your kids were taken. So he realized there were some kids available, so he made a claim to the court, and he said, did you want some kids or some kids for you? Are you kidding me? Wouldn't it think it would have been a good idea before anybody make this decision to have the person who's actually going to be liable and responsible for these children to appear and say they want them? See what I'm saying? An attorney can't do it. An attorney is limited, like you have no idea. Certain things what they can and cannot say. That's one thing they definitely cannot say. That the property is to be transferred over to another without that person, being there. It's like, how do you figure that person really wants that 300 elephants in their backyard. Well, he's got a pretty good sized backyard. He can hold 300 elephants. It's like, before we deliver these elephants to this person, don't you think it would be a good idea for him to, you know, he makes his wishes funny, that it's true? And like I said, too, then if we want to talk about corporate calm, what I say is like what I always do to get around this silly nonsense of just appearing arrogant and like not standing or sitting when judge walks in, judge walks out, all this other nonsense. What I do, and I've been to court plenty of times like that, is judge walks in, I realize that when this started, you know, they say all rise, and then what's funny, I go on the floor and I start tying my shoelaces. That was a trick I was taught, like when I was a Teamster. They said safety check. I was like, what do you mean safety check? They said everything's on right there. They said it's a work slowdown. Nobody on this dock's going to work. Everybody stops working until we get, you know, whatever resolved with management. Like, so what do we do? They said just keep tying your shoelaces, keep untying them. Just do it until we tell you this not to stop doing it. It's just a way of like disrespecting them without disrespecting them. But
right.
what is? I don't really understand. What is he doing by tying his shoelaces? Oh, it's a safety check. Check your shoes. Well, you know, safety first. If we fall down, you're going to pay workman's comp. You don't want to do that. So, you know, it's better safe than sorry.
That's right.
You'd be like a wise guy. You know, but not a wise guy. Not right in their face. It's like, oh, what are you doing? They said, all right. And you went down to the ground. Oh, I dropped a pen or pencil. All right, I realized my shoes aren't tied. I'm sorry. Are we ready to go? You'd be a clown. I mean, I guess it's from being alive for so long, you learn all these things how to be a clown.
Yeah.
Without directly insulting them, like you were saying to me earlier. Well, tell me how you used to do it. You used to say you didn't stand up in court, you didn't do that?
Yeah, basically we would go in before everyone else. The courtroom was just empty. We would get up to the first seat where they had the mic, and we would sit there, stand there and wait, and we would just stand the whole time. So when the judge would be prepared to come in and they say, all rise, well, everyone else would end up rising, but we're already risen, we're already standing. And then when the judge seats himself and they say, oh, okay, everyone please be seated, well, everyone else would sit down, but we would remain standing.
Right. Well, you see, like I said, my little trick is like if I was standing the whole time, they say, all rise, I go down. And they say, what are you doing? Oh, my shoelace, you know, safety first. We don't want to do this courthouse by me tripping on the floor, you know, because this floor's slippery or something. You know, I figure safety first.
That's right. And when the judge would ask us to, you know, to sit down and like that, take a seat or sit down, be like, you know, no, thank you. We prefer to, you know, we're afraid. We'd rather not do that. We prefer to stand to settle this matter, and you know, that's it. But thank you.
I'm a late, really bad Grandpa. Or just find them goofy. That's what you can do. Find them goofy.
Yeah, we could use that for when he tries to get us to come to the bench. You know, why don't I come over here? Oh, my leg really hurts. I got a cramp in there. I wouldn't want to trip and fall on my way. Or
you could do like you have a medical malady. You could say, find some goofy. Say I have angina in my left rupicle or whatever, torso or whatever. You know, just make up some crazy stuff. But like I said, you don't. This is just a laugh to somebody who's listening to something else other than specifically your case. But in your case specifically, make sure that you have the rules of court in, because I guarantee you did not establish the rules of court.
Yeah.
So that's what's funny. I kind of like doing the style of the last minute fire drill, and we're all running around like maniacs trying to get your case through.
Yeah.
It's a lot more fun to have 3 or 4 months to take it slow, but it's fun, you know, being pressured to say, oh, does anybody have a good idea what you should do next?
That's right.
You know, so it's kind of fun in one breath and kind of beyond nerve-wracking.
Yeah, it makes the scales go back and forth in the balance, doesn't it?
It's like I said, I've been hundreds of times, so it's easy for me to play these silly little games with these people, and they don't realize what I'm doing. And then when they say something, I think, do you ever see me sit at any time? And they're like, no. I said, I've always held my standing in common law, haven't I? I said, there's a man. Yeah, I see folks as a man. I'm a man. I always refer to you as a Bob or Sue. I never refer to you by your, you know, your colorful clothing, your colorful acts of being a judge.
Yeah.
I've always told you, under full liability, as acting as a man at full time, making a claim or trying to hurt me, you're trying to hurt another man. So you have to realize that this David man, this counsel, is just another man trying to hurt you. He knows full good and well that those children are yours. And there's no doubt in his mind that he would not like somebody doing to him what he's trying to do to you.
Yeah.
Regardless what this piece of paper says, that he has the right to hurt you, he knows in his heart what he's doing is wrong. Now, he can convince himself in his mind that it's just lovely and wonderful what he's doing to you, but deep down, he's still a man, and he still can't hurt you. There's a universal belief that one man can't hurt another man. I don't care what the piece of paper says. I don't care what that man in the black robe tells you what to do. I don't care what your minister of social, whatever you call those things,
social development.
Right, whatever their agenda is today, because tomorrow they're going to change their agenda, and their rules are going to be 180 degrees opposite, and then everything that you did today is going to be deemed wrong.
Right.
So you've been doing all wrong all these years. Well, now they came up with a new proposal. Now they're going to switch the code around, and now everything you can pass is that. No, I only operate one place since the day I was born. I either do it. Either I'm doing something, it's either good or it's bad. And you feel that little bit in your side of you that you know what you're doing right or wrong.
That's right.
And I don't care how he convinces himself what he's doing right or wrong. So you got to understand, these people have no problem keeping your kids away from you for the rest of their lives. So, but you don't look at them like, I hate you, I hate you. You just say, this is not if you stop, and I'm not going to knuckle down and just be intimidated by you folks.
Exactly.
This is my court. These are my rules. I have this right according to, natural law. You don't have to use God or the supreme being. You have a natural right. You have rights to control your property. And the church gives you any nonsense about property. I'll try to find the John Locke quote. Because it's like, he was saying, well, Lincoln freed the slaves. It's like, yeah, but what did John Locke say about property? Property is what a man claims that is property to his person, exclusive to all others within a society, for him to enjoy exclusively of all others. Is that not property? Like my heartbeat and my dreams, my hopes and my desires, is that too not my property? And let him baffle that little ditty. And he'll say, well, okay, well, then I guess John Locke kind of does trump Abraham Lincoln. It's like, yeah, because that's where Abraham Lincoln got his knowledge. So don't. You want me to trump you? I'll keep trumping you all day. You just little, look before you leap. And then I'll say, well, he who hesitates is lost. You want to play your little games with me? I'll play your little ditty games all day. The bottom line is, does anybody have a claim to that property other than me? Yes and no. And it'll be that simple. And thank God in a common law country, no. In France, that child is part of society. You have no inherent right to that child if you agree to abide by the customs and traditions of that society. That child is part of the community. That's what they're trying to do. In this country, they're trying to make the child a part of the community.
Yeah. And
that's fine. There's a lovely concept. It's kumbaya and hug-a-boo and stuff like that. That's lovely. Maybe one day they'll figure out the DNA of the being and get rid of all the anger, lust, greed, gluttony, avarice, fear, hate. They'll eradicate that gene and we'll all be lovely, happy creatures. But until that day, I don't want nobody touching my kid because I don't trust nobody.
Right.
With my kid, that's my kid. Don't tell me you have good, will for my kid. I will only do what I will do for my kid, and nobody else will do what I will do. And you don't have to explain it to anybody. It's universally accepted that everybody understands this concept about a child and a mother.
Yeah.
So you don't have to go about that. But what I would do if I was you, establish the rules of court, give them in the form of a notice, explain that the honest court to be holding a preliminary hearing for the return of the property, and if there's any claims that come forward, the trial by jury date will be set 1 week from now. There you go. And if nobody comes forth with a claim for the possession of this child, this man in the black robe before us, who's ever going to sit before us, for a representative of this venue, a representative of this, whoever the clerk assigns to sit before us, he's going to take he's going to be witness to what occurs today, the event, that nobody came forward with the claim, and that my order for the property 1, 2, and 3, 4, also known as children, are to be returned to its original place of origin by 1 a.m. And then once you get that order, then you go to, well, I don't know if you folks have sheriffs in the mounties, then you bring that order down to the sheriffs in the mounties and say, help me regain my property.
Right, here it would be the sheriff.
Right, because like I said, if they say you want to do something similar, what you folks call a writ of attachment or writ of sequestration, that's fine. But a writ of sequestration is more like saying, if you really thought MOSD folks, whatever the people out there, the social service people are hurting your children, you could move for a writ of sequestration and say, I want those children, my property, removed from those people because I think they're in great danger and harm. And if you could, can you relocate them if you don't want to put them in my custody and care? Can you please bring them over to a Catholic orphanage? Because I trust those people more. You see what I'm saying? That's a writ of sequestration. I'm not saying you're doing this for you. I'm just making this available for ideas for other people to use in the future. Not this isn't for you alone. I'm just saying, throwing it out there for people who might listen to this stuff.
That's right.
Like,
what different options are that are out there that are available?
Right. If it's real fear that the social service people who are holding your children in certain providences and states are actually placing with a maniac family, or do you say, well, we gave services a hard time, so they're going to pick the worst foster care family for my children, and so my children get beat up because we won't just knuckle on that and sign damn contracts. You make a motion to the court to do a law. We'll explain motions and orders some other time. You order the court that you want your child moved from that place and placed someplace else. And we'll do that some other time. Somebody wants to talk about a writ of attachments or writ of sequestrations. We'll do that some other time. But your big thing was when you walk into court, how you act, set up the rules, say why I'm sitting on the left, because it's custom to you people so you don't freak out. The guy's taking over the right-hand table with them. We will sit at the left-hand table. But at no time do you think that I'm not prosecuting. I'm thinking that property is mine. And regardless of where I'm seated, the fact remains, if a claim doesn't come forth before this court by 10 a.m., the clerk, the magistrate is to recognize and witness to the court clerk that she is to stamp our orders and deliver them upon us. And then you can do whatever you want with that order. You can go down to the sheriff's department and say, well, I got an order. The sheriff says, well, you know what, we like writ of attachments. So why don't you go get us a writ of attachment, or like a warrant in debt, go get a warrant for us, and we'll go get it. And then I'll explain to you a little bit about bonds and stuff like that.
Yeah.
Right now, you don't really need to know all that stuff. So this was just basically how to act when you walk into the court, and how to just kind of try to get away from all that crazy. Should we stand up? Should we rise? Should we speak? Should we not speak? And like I said, the best thing to do is you give them the rules. As long as you give them the rules prior to being there, everybody knows what's going on. It's like, sir, did you not read rule number 2? But if anybody's making a claim, they could bring the claim forward to me. Well, they could hand their claim to the bailiff, and the bailiff could hand you a copy, and the bailiff could hand me a copy. Why am I not getting a copy of the claim? I'm going to be the one who's going to judge whether or not we're going to share this property. And if I choose not to share this property, or the proposal that they're throwing across the table at me, I'm going to say, you know what, we've reached an impasse, and now we have a matter of controversy that is going to be standing for all times, again, between us. So we are going to have to move to before trial by jury. And does everybody have a problem with us being here next week, same time, getting the jury convened, and let the show get on the road? Anybody have an objection to that? Because, like I said, court's open 24 hours, 7 days a week. You can hold trial by jury at 3 o'clock in the morning. There's really nothing they can do about it. I did that with you. Tommy said, oh, Karl, please, let's be reasonable about this. He says, can we convene in 14 days? I said, well, let me tell you what. How about we do it in 30 days? He said, 30 days? He said, I thought you said court is open 24/7, 365. I said to the judge, if I call you up at 1 o'clock in the morning, what happens? He says, I'm supposed to call the state's supposed to convene, we're supposed to come down here and hold trial. I said, that's right. He said, Karl, please, can you be reasonable about this? I said, what do you propose? I said, the judge. The hearing officer, what do you propose? He said, how about 14 days? Give me 14 days because I live pretty far away from this county. He was coming up from Montgomery. A big county down there by Montgomery. He said, can you give me a little heads up? How about 14 days? I got things to do in my courthouse. I said, okay. So I said, how about I give you 30 days? He says, wow, that's great, 30? He says, that's very reasonable. I said, buddy, I got to go to Virginia. I got to lock up a farm. I can't be here at 1 o'clock just because I wake up and say, oh, the king's convening court, it's 1 a.m., everything chop chop. I said, I still got to drive 600 miles to get here. I said, so believe me, it's fine by me. So I go, well, God bless you. At least you're reasonable about this. See, when you really know the rules of the court, and then who's running the court, and then you're the prosecutor, and you're the king or queen, you're the one who's calling the rules. And they have a certain established set of rules. The court is open 24 hours. Well, here in America, here in the United States, it's 24/7, 365. So I don't know what it is in Canada, but the rules that are well established, and you can find in every single constitution or every single code book in all these states. It always says the same thing. Courts are never closed. So they might just simple word like that, courts are never closed. That doesn't. When you say, well, the door closes at 5 o'clock, you could always go to the sheriff's department. They'll ring up a magistrate. The magistrate will come down, and you can conduct court in front of the magistrate. He's a witness before the claim at 2 o'clock in the morning. Whether you're filing a criminal complaint that somebody broken into your husband, busted your nose, the magistrate will wake up and come down and take your claim. The sheriff will go arrest your husband at 2:05, and there you go.
Yeah.
Then when the clerk of the court opens up for business 9 o'clock, the magistrate will just hand you the paperwork. Say, this is what happened last night while you were sleeping. File it. Put it, give it a case number, routing number, whatever you wish to do. Court clerk. I'm going back to bed. So, is there any other questions you really had about Wednesday?
No, I think that really helps kind of clarify the process. So, what would we title our notice that we're sending to outline the rules that we're
Notice.
Just a notice, okay.
Or lowercase. Notice. And underneath this, say notice, and then say our notice, and then underneath it, you can do I like to do it. Rules of court. You can make rules with an uppercase R and court with an uppercase C, because what you're saying is, by doing one uppercase like that, you're saying you believe court has duties, responsibilities, and obligations. You're saying the court has no rights. But what you're saying is the court has duties, obligations, and responsibilities. So when you say rules, you're saying that we have no rights, but what we have is duties, obligations, and responsibilities to abide by our own rules. Like if we operate outside of these rules, you make the king and queen aware that we're operating outside of our own parameter and rules that we establish for this court, and you could hold me in contempt of court. You see what I'm saying?
That's right.
You could be held in contempt of your own court. So that's why instead, like I said, make notice in lowercase, but I'd make the rules of court, rule uppercase R, and C uppercase C.
Mm-hmm.
When you do the honest court, like I said, you can do it in all lowercase like that if you want, because you believe you have exclusive rights to everything within that honest court. The honest court could be all lowercase, that's fine.
Okay. Can you spell the honest court?
Yeah. Mm-hmm. Oh, yeah, and then every time you want to refer back to the honest court, just say said court, S-A-I-D court. That way you don't have to keep saying honest court, you say said court.
And how do you spell the honest court?
What's your last name?
Oh, you were using our last names. Okay, yeah, so the Arsenal court.
Okay, well, you wanted everybody to know Arsenal.
Okay.
That's what I was saying on that. Kind of figuring that you kind of figured you knew what I meant. So, okay, if anybody's listening to this call, you use your last name. Because if you look at any Supreme Court rulings, like Hale versus Hinkle, it'll say, in the Hinkle court, the lower court decided this. And then it moved up to the Circuit Court, Court of Appeals in New York, and in the Hinkle Court, at the Court of the New York Superior Court and New York Supreme Court, the New York Supreme Court in Hale versus Hinkle ruled that the accountant for the banana fruit company, Mr. Hinkle, was denied. So Mr. Hinkle now has brought it before the Supreme Court. So the Hinkle Court has now moved into the Supreme Court of the United States. So what it is the Arsenal Court now is now moving into this venue. It is the Arsenal Court. So what you folks will call the Arsenal Court, and then you can put the word at, and then say what court are you actually competing, like the New Brunswick District Court?
Court of Queen's Bench.
Okay, is that all it's called? Is it called the New Brunswick Court of Queen's Bench?
We actually called it the St. Jonathan Court.
Okay. what I'm saying is, what do they like to title or stylize on their letterhead? How do they like to address themselves?
They refer to it as the Court of Queen's Bench in New Brunswick.
There you go. Beautiful. So you say it's the Arsenal Court at the Court of the Queen's Bench of New Brunswick. Exactly the way they stylize it, uppercase, lowercase, however they like to do it that way. Because it's just a cause at this point. Because you basically, everybody knows where this building is. So instead of being confused, you're saying, does everybody know the name of this? And they say, yes, okay, fine. Then the Arsenal Court at Queen's Bench, blah, 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 blah. We'll have a hearing, blah, blah, blah. There you go.
And, yeah, so I think, so basically we're outlining our rules of court, you know, we're the prosecutor, we need the minister to come forward to press for a claim on the record, if he has one.
You leave it vague. You don't say you don't you say are accepting any and all claims. You don't really use prosecutor because prosecutor means just a hunter. You know you're a hunter. So it's like the hunt for deer or something like that. I don't have to say call the hunter. You see what I'm saying? Mm-hmm. You don't have to define yourself as a prosecutor. So all you have to do is say on that court is accepting all claims. Property 2, 3, 4, C, whatever. And then you can name put their lovely figures and everything else. So that's fine.
Okay.
But to say that one has 1, 2, 4, C exhibit 1, 2, 3, 4. That's fine. And say we're accepting all claims, and may all claims. Oh, and we accept all claims from 9 o'clock to 10 o'clock. And it's just simple like that. Don't direct them personally because what you're trying to establish is people on the right hand side who exist. There's no Goric or whatever aberration that somehow they have an opinion of voice that should even be heard. You see what I'm saying?
Yeah.
You're trying to make it like they don't even exist. I don't even know where these people get their authority of power, jurisdiction. I don't understand why these people is building at this time. I have no idea what extent things they can do what they're doing. So you see what I'm saying?
That's right.
You're trying to basically, talk to the hand. I don't even know what you are. I don't know. You're just some rule book that sprung out of the ground years ago. My people, a lot more. There's agencies on this planet.
That's right.
See, so that's got to be vague about who's making the claim. See what I'm saying?
So we're basically, our rules of court, when we lay them out in the notice, we're accepting all claims from, say 9 till 10. And, if nobody brings forth any claims by 10 o'clock, then we want the judge to basically record that the other party didn't show up, nobody pressed a claim against for the case.
Instead of saying, say the representative of the court clerk's office, he's going to be a representative of the court clerk. Who's ever been assigned to court's office is the witness that no claims have come forth. And he or she to bear witness and take my order and present it to the court clerk and have the court clerk file it and return it to me as a witness that no claim has come forth.
Perfect.
There you go. You want to get looking at him like this isn't a beauty. This isn't American Idol. He's not your guy.
Right.
And if the magistrate, the guy in the black robe, says, "No, ma'am, I'm sorry, but the MSF Social Services did bring forth a claim, but we can't bring this to the clerk, or we can't have what a stamp at this time." It's like, good. Then you read the rule. If you believe, if the assigned person, the court clerk's office, at this time believes that there is before this court a counterclaim to our claim, then we want our jury set up as soon as it's available in this venue to seat it. And we say we'll come midnight. We don't.
I don't care what time it is.